Where is that number? Well, the questions then, Kevin, if we get any, they can write them in. I'll kind of watch them.
Yes.
Okay.
Oh, Wayne has a jacket. Hey, Michael.
Got your little Saturday Night Fever going there.
Hey, if you guys are gonna do your thing, I'll do mine.
It goes, yes, more of, I think, Miami Vice.
That's the idea here.
Yes.
Oh, I'm on.
Michael's on. Okay.
I'm on. Are we going to do the videos on the side is how we're doing it?
Well, we're going to, Kevin, go ahead. Sorry.
We'll just do the first two slides, and then we won't use slides. It'll just be talking heads, you guys.
Oh, so we are doing video. Okay.
Yes.
There you
yes.
go.
We had discussion.
Better. Give me a few minutes. Hang on.
Yes, we had discussion before. Okay, I have 11:58, so I need. We're missing Debbie. Have we heard from her?
I have nothing. Well, she's kind of first. Anybody, if she's late, want to tee up the first topic?
What is the first topic?
We can go. I'll start with the first.
Here's
Google, Facebook, kind of tracking apps. What we're seeing, kind of, starting with that, and then we can go from there. But I'm going to give everybody a minute, 30 seconds to a minute to introduce. I'll introduce you, and you can tell where you work, what you do, instead of me trying to read off a screen. So whatever intro material you want, we'll go with that. And we'll start with Jason, then we'll go to Wayne, then we'll go to Michael, and then Debbie. She hasn't emailed me, so hopefully she's just running a little late. Or called me.
right. She's not responded to my emails. Sorry, Wayne. I just saw your email just now. I'm sorry I missed it earlier.
No, it's not a problem. Not a problem. I figured it out. But thank you.
So, okay, 1 minute, and I'll start broadcasting.
Then Michael, can you give me your cell real quick in case we need it? Oh, he's frozen.
He's also he's grabbing his jacket.
Yeah,
he's coming back, or at least a shirt.
Pressure.
Was under the impression this was not going to have video, but since it will, we seem to be missing somebody, aren't we?
Yeah, Debbie's not on yet, so I'll handle that piece kind of, and we'll run with it, and hopefully we haven't heard from her. Hopefully everything's fine.
Right. So hey, Tom, since we're only doing the first two slides, how about I'll just do it. I won't give you control. I'll keep them, okay?
Yay, Debbie, you made it.
There you go.
Okay, we have a bell. You ready?
Yep.
All right, aloha. Let's do it.
This is so interesting. Hello, welcome everybody joining us remotely to Privacy in a Post-COVID-19 World.
Hang on.
We live, Kevin?
No.
Hello, guys.
Hey, Debbie.
Hey, Debbie.
Gained to Debbie, but we've lost our slides.
Oh, no.
It's a fair trade.
Hold on, all attendees. We will be starting momentarily, if you can hear this.
Big enough for everybody?
Yeah, I know.
See the attendees number growing. Kevin, I see we're recording.
We are.
We're good.
Alrighty. Yes. So welcome to the Masters Conference webinar event on privacy in a post-COVID-19 world, brought to you today by the Matzen Consulting Group. My name is Kevin Clark, and I'm an attorney in Dallas, Texas, and I run the litigation support department at Thompson Knight. And I will be today's host for the program. We'll be getting started with today's program in just a moment, but before we begin, just a few program details. I would like to remind you that today's program is being recorded and will be provided for free to the registration attendees about 48 hours after the live event. A link will be emailed to the event, to the participants and attendees. We encourage you to ask questions at any time during the program by typing them into the Q&A fields. And your questions will be answered by the panelists either during the presentation or at the end of the presentation at the discretion of the panelists. A little more housekeeping. The webinar ground rules. Content is for educational purposes only and does not constitute legal advice. Questions posed by and opinions offered by the participants are for the sole purpose of improving our educational value and do not constitute legal advice. The views expressed by the members of the panel belong solely to the panelists themselves and do not represent the views or opinions of their organization. And now to get started with our program, I would like to introduce you today to the moderator, Tom Matzen. Over to you, Tom.
Thank you, Kevin, and welcome everyone. We're excited to speak today about everybody's world has been changing in light of COVID-19, and we've assembled a strong group of panelists to answer some questions, share findings we're seeing in our walks of where we work and different questions we're getting from our clients. Again, my name is Tom Matzen. I'm the president of the Matzen Consulting Group, specializing in privacy and data security matters. I'm going to have the panelists do a brief introduction of where they work, and then we're going to jump right into some of the topics we've come up with, hopefully. And again, as Kevin said, if you have questions specifically, you can utilize the chat feature to all panelists, and I will try to work them in. We will do our best to answer as many as we can. I'm going to start with Jason Schwent, joining us from St. Louis, Missouri. Jason, if you could give a brief description about your practice and where you work, and then we'll move on to Michael, Wayne, and then Debbie.
Sure,
Jason?
Thanks, Tom. Yeah, I am senior counsel at Clark Hill. I am in their cybersecurity department. My work involves handling breach response for the most part, and a fair amount of compliance work, including both agreement review as well as compliance counseling related to data privacy and cybersecurity matters.
Thank you, Jason. Michael?
Thank you, Tom. And thank you, by the way, for that picture. That reminds me of what it was back when I could get haircuts. Now that I've got my nice long pandemic haircut here. I'm an attorney with the Xpan Law Group. We're a cybersecurity and data privacy boutique law firm, and I have been involved in privacy and in particular also e-discovery for many, many years. So thank you for inviting me to this.
Thank you, Mike. Wayne?
Wayne Matus. I am the co-founder and general counsel of Safeguard Privacy. We are a SaaS software privacy compliance platform for corporations, law firms, and consultants to both assess, manage, and maintain their compliance. Prior to this, I was a managing director at UBS and the founder of the privacy group at Pillsbury Winthrop Shortcut.
Thank you, Wayne. Debbie, go ahead with your background, and then since you're kind of our lead off, we can just scroll into the first slide, if that's okay. Talking about some of the framework with Google and Apple and some of the tracking applications. So let you take over for a few minutes, and then the rest will join in.
Okay, fantastic. Thank you, Tom. Thank you to the group. Happy to see everyone. My name is Debbie Reynolds. I'm the CEO, founder, and Chief Privacy Officer at Debbie Reynolds Consulting. I work with multinational corporations on operational data privacy issues, all the way from privacy policies in terms of just the language of how that looks, but also trying to tie what people say to what they do in their day-to-day operations for data privacy. So I've been involved in privacy like Tom for many, many years. I segued from e-discovery and have been doing that for many years. So I'm very happy to be here. Do you want me to start with the tracking?
Yeah, it's going to give a little. So we've broken this for the people listening and watching. We're going to hit a few topics here at the beginning directly relating to COVID, what employers are having to deal with, what rights of employees. We're going to storing medical data. We're going to hit a lot of those practical issues. And then towards the latter part, we're going to update on CCPA and CPRA. And so we're going to kind of run that gauntlet. But Debbie, yeah, you can go ahead and start with sort of the news is kind of chock full every day with COVID news, with now, after the initial shock of the medical issue, it seems to be the privacy issue, especially in the world we live in, which maybe it's a smaller world than we think, but all the people we know start talking about, what are the privacy issues around testing, asking medical questions. And so, Google, Facebook, some of the big Silicon Valley companies are coming up with, quote, helpful solutions, and let's kind of look at what exactly they want us to do or what they think we should be doing.
Okay, excellent. So I obviously have lots to say about this, but I'll try to keep it short. So because of COVID-19, a lot of companies are coming together trying to create these COVID applications to do contact tracing. So Apple and Google, they've enabled their products to have a capability so that phones that are in proximity to each other can send beacons to one another to bounce off of one another, so that if someone downloads a particular app in a different country, they sign up for these apps, they will be notified if there's someone who they've been close to in proximity for over, I think, 10 or 15 minutes or so. And then they would give them some instruction either to get tested or to quarantine. These apps are relatively controversial. All these different countries have different laws and how they're implementing these apps, and it's not the same. Even if you have an app that looks like it's the same, it's definitely not the same. So because there are different privacy laws in different countries, they're all grappling with what's the best way to implement these technologies without stepping on the rights of individuals. The biggest challenge I see with contact tracing apps is that information that typically would have been protected or would have been only given to medical professionals are now going into the private sector voluntarily, because if you sign up for this app, that information isn't protected the same way that medical information is typically protected. So people are concerned about having the transparency with these apps about what's happening with people's data. And even though companies are saying that they're developing it in such a way that it's going to be anonymous, there are inferences that can be made technologically about who has the app. You don't even have to know what people have said about having an app, but it's definitely a concern. And in countries like Australia, they've actually passed new legislation around contact tracing apps because they saw that their current framework wasn't sufficient to cover this particular technology use. So it's just different in different countries. Currently it's voluntary in most countries. And in terms of the GDPR and CCPA, these are definitely issues. So for the CCPA, it's about you as a consumer and your rights, but the GDPR is much more broad in terms of who's covered or who's protected, because they're thinking about individuals as opposed to consumers. So those rights are a lot more broad in terms of contact tracing.
Does anybody else in the panel have a problem with Google and Apple said, hey, trust us, we know what you need, historically and how they've handled data? Do you see, if it's voluntary, I'll throw this out to everybody, is, the point being contract tracing, right? If you had COVID, where have you been? Then they can test people that you're in contact with. And other countries, I think South Korea's had pretty good success with it, but they were doing tracking within 2 weeks of the spread. Is this a United States problem where we just don't trust these companies enough with other countries?
If you want to get a little bit on the technical side of things, what Google and Apple have released are frameworks or spec sheets for how app developers that are to be compliant with their view of app development should handle the development of the application. It's really a guideline. What they do to facilitate that is they, in the back end, enable the recording based upon cell phone data and Bluetooth. Cell phone for your geolocation, Bluetooth for who was near you. And that can work. You can rely on one, you can rely upon the other. But what we've seen is people who create applications do not necessarily follow the standards that companies impose upon them. And while access to the database is supposedly limited by the user under these standards, we've also seen people get around the limitations on access to databases. And while the database is supposedly self-deletable by the individual user, we've seen people get around that. And as to Debbie's point, other countries, England, for example, may not want to follow those particular standards because they may not like the self-deletion aspect, and they may want to actually have the ability for, in their case, it's the NIH, but the government go down into the applications and pull it out and do the more aggressive app tracing that you saw in South Korea. So this is a very complex kettle of fish.
Yeah, we've, hey Wayne, just to further saying that the ICO in the UK released its guidelines, and we both have commented on them on LinkedIn. And what did they say right in the guidelines? No geolocation tracking. That's not acceptable under the GDPR. And what happened the next day? I think maybe 2 days later, the UK releases an app to do contact tracing that uses geolocation tracking data. I think we're all clearly allowed to worry about scope creep here. We've seen it before with too many things. Do I think this is the way out? Yeah, I think we're going to need things like contact tracing, but we need to make sure that they follow the frameworks and that the people who build them follow their own frameworks.
No, thanks, Mike. It seems to me that if not everybody's using it, there has to be a point, a statistical measurement of if only 60% are using it or 40%, then it's probably not going to be very helpful. You almost need enforcement to get it to 80 to 90%. And I just don't see that happening. Is this a realistic, in our country, right? Other countries may, have different trust of levels of companies and governments, but and I know Facebook, the Google, the applications, they're not saying everybody must use it. And that's, we're going to get into that. For example, can an employer require an employee to use a tracking app? What can employers make employees do in managing the health of their workers to keep it from spreading to other workers? Is there a segue there for maybe a big company has their own tracking app based on those specs that Wayne was talking about? And now, can we send you home, or can we get rid of you as an employee if you don't use that? Michael, do you have anything on, you seen any questions related to employer-employee, either forced tracking or other reasons, forced temperature taking, forced, you can't come into our building unless you take a swab test, What are you, I'm starting to see lots of questions without a whole lot of answers right now.
All right, so two things. One, I'll object this to the compound question, but yeah, if I want to do the segue, let's take it as a segue. And of course, the answer is I'm going to do the typical attorney thing. It depends. Can employers require employees to do certain things and provide medical information and tracking? It depends. You know, we need to remember this is new. Anybody who was out there who was doing risk planning, risk mitigation and such, they didn't have this on their bingo card, okay? You know, nobody had planned for a global pandemic in square, you know, G4. This is new. In fact, I would tell folks, if you want to find out what the reactions are so far, go to a page at a site called justcapital.com. And they've got reports about where companies in general, where the S&P 500 is on this. And let me tell you, it's a very long chart with lots of different bars and all over the place on what companies are doing. And some are sophisticated and some are not. But if you are doing this, I think you need to stick to some general rules of privacy and you know, stick to the facts on what you record. Limit the personal data, limit personal info, limit the access to the employees who need to know this, and in particular, third parties who need to know this. Use anonymity as much as possible in both what you're recording and what you're communicating. You know, if you need to say we are shutting down the office in Topeka, Kansas because of a positive coronavirus test, that's a lot better than saying we're shutting down the office in Topeka, Kansas because of Bob. Okay, what's the deal with Bob? You know, store it securely. Even if it's physical, store it securely. Destroy it when it's done and not needed. And again, avoid the scope creep. Use it for the specific purposes that you have and don't go further with it. And in terms of the contact tracing apps, it's potential. It's potential you could do this under certain parts of OSHA that require, let me read this correctly, to furnish employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm, Section 5A1 of OSHA. As well, EEOC has listed guidance that testing could be a, quote, business necessity. There's also state agencies that have said that. But let's be clear, there's a lot of different laws here. There's a lot of different rules, and it's a can of worms if you start doing this. There are off-duty laws in California, New York, and other states that limit what you can track for people when they're not working, what you can require of them. And as well, if you do this, let's say for the EEOC, you know, under that guidance, and you implement tracking, you say, okay, we're gonna go high-risk people. Everybody over 65, you'll be traced. Congratulations. You know, I've got friends at the EEOC, people I've come to know and really enjoy working with. You really won't get to know them and enjoy working with them in that way if you've got yourself a prima facie ADEA violation like that. So you have to be very careful. And then I will add one final thing. I'll go for it. I think
No.
Go for it. I'm on too much of a roll. Go for it. Are you Crockett or Tubbs today? Which one are you?
Crockett.
Which one are you?
No. Yeah, you have theme music going.
Cue that song.
The U.S. system of privacy, with leaving aside the CCPA, is essentially a disclosure system. You can do almost anything you want with a few exceptions if you disclose. And if you disclose, people tend to not get sufficiently upset to bring lawsuits, and juries tend to not to get sufficiently upset to give big verdicts. So if I had one major piece of advice to corporations, it's whatever you're going to do, just let it all out there. Say what you're doing, say why you're doing it. Let people understand and have the opportunity to go revolt and protest and the like, because you're always going to be able to say, but I told you so. And in very rare circumstances, that won't be enough.
So I think that's a very good point. And at least particularly in America, we have the ability for employees to consent. But I think we should also be clear, and I do want to knock this one elephant in the room down, is HIPAA. I hear it all the time. I'm sure we all hear it all the time. In fact, on my little local Facebook group for my tiny little middle nowhere town here in Massachusetts, I've had folks post things saying, oh no, I'm worried about so-and-so might have this, but I don't want to mention their name because of HIPAA. We're all HIPAA. There's a big misconception that the privacy rule applies to all of us and everybody in all situations. And this gets to be one of the rare times I don't have to say it depends. I can say in general, it doesn't. Unless you are a covered entity, you're a health plan, or you're keeping or transmitting electronic health information, or you're a business associate thereof, you're okay. And as well, even if you are a covered entity, and this is done in the course of employment and it relates to the employer-employee relationship, then you're also in a situation where HIPAA may not apply. I don't think you'd want to just go ahead and just do it willy-nilly. You should call us, and hey, my email address is there, right? But yeah, this is not something that this information, HIPAA, is going to create some terrible ban on it.
Well, and I think going back to contact tracing, I think that's one of the big issues with contact tracing, right? So if an individual volunteers their information, HIPAA doesn't apply. So they've voluntold or someone their information, and there are no health protections for that. So that's, to me, the big issue with contact tracing. And I will add that only 45% of people in the world have cell phones, so smartphones. So, so 45% of those people, a fraction of those will use contact tracing. And in my opinion, contact tracing is a profession, it's not an application. So.
Well, one other note on that is, while generally with privacy laws, with the CCPA, and with, at least in the US, with privacy laws, we've seen pushback, that there's been sort of a corporate resistance to some of the protections that are being implemented. The one area where you tend to not see as much pushback, and where you tend to see a general move towards additional protection, is when it comes to bioinformatic information. That is, there's some disagreement in terms of some of the scope, in terms of how enforcement is going to be handled, but you see states, blue and red alike, who are pushing forth bioinformatic protections, and it is sort of universally accepted. So while there's debate among corporations and individuals about what information can be collected and what can be done with it, the one area where they do tend to agree, and where there is sort of an overriding trend, if you want to call it that, is for the protection of this sort of bioinformatic information, which it's not there yet. And we don't have a lot of things addressing what is happening with this COVID law, because this is an unforeseen kind of area regulatory wise.
And that's a great point. And thank you for bringing it up, Jason. I mean, your temperature is not your ID, okay?
Correct.
But if you're going to have an office building or a factory and you're going to take everybody's temperature, that's going to kind of slow things down a bit. That's going to be a big line and tough to socially distance. We're talking where a lot of companies are talking about doing, hey, we'll do facial recognition and then a contactless temperature thing. Bam, that's an ID. And if you're doing that in Illinois, you may have a problem. Or even Texas or Washington, which have similar acts, they're just not private causes of action. As well, now you've got the CCPA, SHIELD Act, Vermont's got a new law coming that covers an amendment to their laws, and other states have this, where now your level of protection for that information, for keeping it from a data breach, has gone way up, because you don't want that to be the problem. And as well, if we're going to put an EU spin on this and bring in the GDPR, there's a number of DPAs and the EDPB as well have said, no, there's going to be limits on this. And by the way, we have had a question from the audience that I will take that talks about, wouldn't the employers have the employees sign something? And the answer is, yeah, I certainly would. Again, that goes to Wayne's point about consent, but do keep in mind, getting back to the whole EU thing, that there are EU member states that have specifically said, Germany, and I know Germany has said, I think France as well, Wayne can correct me if I got it wrong, that because of the employer-employee relationships and the imbalance there, that consent is not a valid means for lawful processing. So just be aware, consent doesn't always work everywhere.
I'll throw this out there, Mike, and I'll let Wayne jump in. What about the vital interest exception in the GDPR? Couldn't a multinational company with EU and US employees have a legal basis of vital interest of their employee for their health? Or where do you think that would come out?
Look, the answer to that is yes, but the but goes to Michael's point, which is you better protect that information and you better not disclose it willy-nilly. You handled the collection part. Yes, that handles the collection part.
As I guess you heard it here, the butt stops here. You know?
Yeah, so thanks for that question. Hopefully that answers that. We're gonna, looking at our time here, you know, in addition to asking employees for personal health information, you know, in light of COVID, we're also seeing an uptick as a result of the remote acts, people working remotely from home. We're seeing an increase in phishing and data breach issues. So this is another topic relating to post-COVID. It was always there before, but we're actually seeing an uptick. And I guess you could reasonably anticipate that. But Jason, I know in your practice, you deal a lot with data breaches. What are you seeing? Are you seeing noticeable differences in the trends and, you know, companies having issues with workers working more remotely from home, phishing attacks? I see ransomware attacks. They seem to be way up in the last 4 months. What are you seeing?
I mean, I think with ransomware is always there. It's always a problem, and we've seen just as many cases of that post-COVID. I think the biggest uptick that I've seen with my practice has been with business email compromises. We have a lot of employees who are working remotely. Even for those businesses who are partially open or are starting back, there's still a lot of remote work happening. And what that has done has taken existing protocols that are in place and it has jostled them all up. And so you have, where you may have had policies and procedures in place to protect information and protect how you're handling things. For instance, how you're handling wire transfers or automated payments. With the COVID changes and not just the move to remote work, but the move from remote work back to the office. All of those changes have interrupted those protocols, and you've had people having to adjust, and those adjustments provide opportunities. And so we are seeing a lot of phishing attacks coupled with wire transfer fraud and automated payment transfer fraud. So what's happening is, the other thing that's at play here is whether it's COVID, whether it's protests or riots, or whether it's in a month murder hornets, we're seeing emergencies on and very, very urgent things happening on an almost daily basis. And that urgency is what attackers utilize to gain access. And so there are so many things that they can use to get an employee's attention, to get them to click on a link, to get them to recertify, you know, their access to a particular system or database or whatever. There's so many opportunities for that there's a lot of chances for phishing to work. And with that phishing, they get into those environments, and there's a huge uptick in business email compromises. With that, the one thing that we are seeing as well is Office 365 is a huge factor in a lot of these, not because it's a bad system or because it is a bad piece of software. Cloud computing is a much safer way in a lot of aspects to keeping your data on site. But the one thing that I will suggest for those companies who are using Office 365, Microsoft a couple years ago stopped doing universal audit logging for those email accounts. That universal audit logging allowed us, after an event occurred, to see exactly what happened within an email account. Without that information, when you have a business email compromise, we can't tell what was looked at, what was accessed, what was transferred. And so we have to rely on other secondary information, which sometimes can tell part of that story, but many times it can't. And what results is we end up having to data mine that email account to see what sort of personal information was in there, assuming there was access to all of it. So what I can tell you is if you have Office 365, an Office 365 system, turn on universal audit logging. It will allow us, if there is an event, to go back and to track exactly what happened. The other thing, if you have Office 365, turn on multi-factor authentication. Microsoft has put out a report saying that over 95% of their cybersecurity issues that happen with Office 365 can be prevented if you use multi-factor authentication. It is probably the single most effective tool that you can use to prevent a breach. And it is, given the ease with which it can be implemented and the relative ease with which it can operate, it is a huge factor to decreasing your exposure.
I think that's a great practical tip. One other thing I'll throw in is the DPO for a couple of companies. We've revisited our training in the last month and beefed it up and gone through webinars at a company level about, security issues from working from home. It used to be like a little one page in some corporate manual about remote access working. So we've definitely gone back and said, yeah, we need to make this a much stronger document with much more what you can do and what you can't do. And it's been pretty well received because once now everybody's, again, the unforeseen, the changing of just day-to-day work has, causes more holes. And there's plenty of bad actors looking to penetrate that and do some damage. I don't know, Debbie, are you seeing in your practice, I know you deal with a lot of issues like this, are you seeing any of your clients revisiting how they let people work from home, maybe firming up their security?
Oh, absolutely. I know a lot of people before COVID-19, some companies, there were certain people who could not work from home. So it was kind of like more of a privileged thing for certain people. So being able to move, partial or most of your workforce at home, there are a lot of gaps there because they have to really think about the whole enterprise, whether that be them, buying equipment for people, setting up, more secure channels for people to look at things more than email, being able to really educate people because, there's always someone in the office that isn't as computer savvy as other people, or the person who always has their post-it note or their password sticking around. Those things still become challenges and are bigger challenges when you're in you can't walk down the hall and talk to that person. So I am seeing people trying to firm that up. I'm seeing people trying to figure out, especially with the temperature checking, I've seen businesses, some of them make you sign, a waiver of some sort, or something that says that, you make sure you didn't have a temperature and, you understand this data collection. And I've seen some people, like they try to record it for employees, but, that's a slippery slope. So, my advice to people is, especially if you're doing temperature checks, make sure if you are recording them, you need to have a good reason why you're recording this information. And if you don't need to keep it or retain it for a long time, you need to be able to be clear on that and follow through on that.
Mike and Wayne, you can go in either order. Just any comments on what you're seeing in terms of the post-COVID working from home causing concerns, issues, threats. A lot of companies have gone to more SaaS platforms that help some remote working, but you're only as strong as your weakest link. And I think we all know people tend to be the weakest link in terms of security. Any practical steps? We'll start with Mike, and then if Wayne, you have any to add about for our attendees to say, suggestions or things to look out for.
I think they've been pretty well covered. And by the way, I think as Jason brought up, I think people are the weakest link, at least until the murder hornets show up. I do want it known. I'll be willing to talk on the next panel we do on murder hornets with, obviously a bunch of murder hornets probably on there. You know, Debbie brought up a really good point, which is if you're doing the temperature checks or any other type of checks, there's going to be, and of course, as attorneys, we're going to be some of the folks who push this, you know, belt and suspenders, be careful, you know, record it all because we might need to show that we acted reasonably. Just keep in mind, you're now creating a whole bunch of data that could come back to bite you, and not just in a murder hornady sort of way, but in a really bad way. And so, you know, resist some of the urge potentially to do a whole bunch just in case you get an inquiry. And in terms of the data breach work, yeah, I mean, it's just at this point, you know, I'm hearing from companies that used to have, you know, a couple of pages of policies, and now they've got whole books on them. Now is the time, and actually now wasn't the time, 3 months ago was the time to update that stuff and make sure your policies and procedures are clear, and make sure your policies and procedures for everything are clear, because people are stressed, people are off their usual routine. You know, none of us actually really are quite sure even what day it is most of the time. And so, you know, when you would think, hey, you know, if you're just sitting in your office and everything's cool, and all of a sudden I get an email from the CFO that tells me to do something really weird and not right, I'm normally going to catch it, but no, I've got my kids running around like maniacs, and, you know, things are just happening, and okay, fine, click that link, and boom, now you're in trouble. So I think it's time to shore up not just your cybersecurity stuff, but everything.
I think that's a great point. I think before we go to Wayne, that I'm seeing that a lot too. I have a client that gave the entire company 4 days off just to kind of refresh the batteries. I mean, policies, plans, they're all great when everybody's dialed in, but I think understanding that the mental well-being of your employees, and they're scared, they're concerned, they're going to be, you know, maybe communication is key. Less legalese is better. And, you know, almost having a calming effect if possible, which normally the privacy team is not the calming effect within the company. I understand that, but coming in with it with that lens of, all right, these are not normal times. Wayne, anything on that topic? And then we're going to move to CC.
Two things. One, you know, I'd like to say that at Safeguard Privacy, we were geniuses in deciding to build a product that sits in the Microsoft cloud where people can work remotely. But it was luck. It just happened. And the reason why I think that decision was so fortuitous, and I think this discussion actually is more important than we've allowed it to be so far, is I don't think that this is a phase. I think, and it's not like this is the new normal, but there are an awful lot of chief financial officers who are looking at their companies and saying, my God, I don't need all these desks. I don't need all these floors. All these people seem to be doing really well working at home. Maybe Midtown Manhattan office buildings are no longer necessary for me, or maybe I can have 8 floors instead of 18. And so when you start thinking about having secure platforms and applications, maybe you should be running your privacy function remotely. Maybe there are other functions where you don't need to have everybody in the office. I think that the new normal is not going to have a seat for every employee at headquarters. I think the new normal is going to be a lot of collaborative workforces, and some companies that we work with are reporting that productivity is up because of this, not down.
Yeah, I saw that as well. I think you're right. I think that's where this is going. So some of these changes and steps that are going to be implemented here over the next few months in response to COVID may be the new norm. Now, you know, I don't know where that's going to lie, but I think it's going to be more, like you're saying, towards more remote working than what it used to be. I don't see a way around that. Happy to hear any differing opinions if anybody on the panel has one. I'm notoriously speak quickly and then think later, so go ahead. I could be wrong.
I agree with what Wayne is saying. you know, I think some of the things that people have been talking about, like with remote work and, you know, collaboration and stuff like that, a lot of it has been lip service up to now. So the fact that we've been forced in a situation where we've proven the concept up to this point, I think companies are looking not to just do the status quo, but looking to do what makes the most sense. So if that makes the most sense to move in those directions, I think that's the way things are going to be in the future. So.
I think it's also worth noting that with the transition and whether, you know, whatever the future is going to hold with this, I think in my practice, what I see with cybersecurity all too often is that cybersecurity, security in particular, is an IT issue that you can throw money at and solve. And that is not the case. It is far more often a cultural issue. And as we've noted, and several people have said, you know, your people are going to be your weakest security link throughout your system. And that requires a system and a culture of security and privacy, both. They do go hand in hand. And I think it takes a real concerted effort to think through, you know, as Wayne noted before, what information you're collecting, why you're collecting it, what you're doing with it. Answering those questions on a cultural basis throughout the entire organization, taking those steps to actually think about what you are collecting, why you're collecting, and what you're doing with it. That is a huge part of the security of this. And just slowing down enough to go through that process can pay off huge dividends in terms of security and privacy both.
Thank you, Jason. I have a question I'm going to throw before we move into CCPA land. We've seen an uptick, if anyone's seen an uptick in business for both privacy policies, training, and cybersecurity technical concerns. I'll go first. Yes, it's hard to say if it was strictly related to COVID, because things were trending up in the contractual DPO world that I kind of live in. And there hasn't been a slowdown. I keep getting more requests to help on projects. But at the same point, maybe Wayne, in the software model, Michael, Jason, from lawyer perspectives, mine's anecdotal, I can only speak for myself, but other colleagues I'm hearing it's been an uptick, but it's hard to say, is it simply because of COVID, or is it because of the CCPA being enforceable here in a few weeks, or is it, so I can't pinpoint as to why, but I've seen an uptick.
I can tell you that the last 3 months are not uniform. I think you have to look at it in two phases. The first half of the last 3 months was shock and contraction and people not doing anything new, including privacy projects. And then the last few weeks or month or so, people are like, well, I guess life has to go on. I better pick up a project. And then you have the California AG saying that he's going to start enforcing the CCPA July 1. And all of a sudden people are saying, well, I was thinking this might not be till next year. I guess I better take the stuff off of the shelf and put it back onto the burner. So I'm seeing an uptick now, and I've seen an uptick for the last few weeks after things slowing down a lot at the start.
Yeah, I think the combination of the two have raised, if nothing else, awareness of the needs that potentially are there, which is a good thing across the board. I think a lot of times with policies, far too often for good practice, but people will draft the policy and say, oh, we got it, put it in the drawer, now we're good. And I think this is an opportunity where they go back and look at what may exist or what policies may be there, and they realize they don't cover what's happening. They don't cover the behavior or the practices that are occurring. And that can be whether they're looking at it because they're concerned about CCPA or further iterations down the road, or because of the COVID response. I think both of those are causing awareness where there might not have been awareness before.
So you've seen the same thing I have with Jason, which is, folks spend a lot of time creating policies, put them in a binder, put it on a shelf, and the first thing they do in an emergency is, oh my God, we don't have time to read that policy, throw it out the window, panic, run amok. I've seen a lot of what Wayne has seen. Folks initially, we don't know, when is this going to end? When is this pandemic going to end? When is this recession? I think we're officially in one now, going to end. When do the murder hornets arrive? I don't know. You can weigh those accordingly. We've seen a lot of slowdown, and we're seeing a lot of discussion. People wanted to talk, whether they want to pay you. I talk to clients, by the way, who tell me that they've got a lot of contracts with 30 or even shorter, payment terms, and all of a sudden they started getting, addendums, one-sided, not complying with the contract addendums of, guess what, those terms we actually meant 120 days. We're seeing a lot of people very nervous over this. I do think business is starting to pick up a bit because, I guess we're all getting used to this new normal. And we have to get on with things, and there are things happening in the world. And with the CCPA, and this will be the good segue back to Crockett or Tubbs, it's happening.
Yeah, I'm seeing a couple questions. I'm keeping track of them. I want to get 10 minutes, maybe 8 to 10 minutes on CCPA and then CPRA. Then I'll throw out the questions that I'm tabulating. So those sending them, I'm not forgetting about you. I just want to make sure, since July 1st is a big date for the CCPA, and we want everybody to walk away from this knowing what the November election ballot in California may bring, because it may affect some decisions you make now. So I'm going to let Wayne go a few minutes and tee up kind of where we are at the CCPA. I mean, it was just a week ago, kind of the final language was put into law, and that we're looking at an enforcement date based on the AG that's not going to be, pushed back any because of COVID. So if you can go ahead, Wayne, lead off this conversation, and then I want to make sure with about three or 4 minutes left that we have time for some more questions.
All right, so let me keep the CCPA part of it really brief because people know it's coming. It's July 1st. AG is going to enforce it. And if you don't have privacy policies in place, there's an assistant attorney general sitting at a desk somewhere in their home around Sacramento that's able to enforce it from home. They don't have to be going into your offices to see if you have an online policy or not. So there are some things that you just better pay attention to, and you can do it remotely. So go do it, because the Attorney General is serious about it. When he submitted the request to have approval, he said, I want it on July 1, and sure enough, you're going to have something somewhere in July coming out of them. So let's talk about something that people aren't paying attention to, and it's a really, really, really big deal. The Californians for Consumer Privacy Group was the group that did the CCPA. And what did they do? They had an initiative, and the CCPA became a compromise in the legislature to keep that initiative from going on the ballot. Well, they're very unhappy. They claim that companies weakened the CCPA. New technology has evolved in ways that has exploited consumer data even more than 2-3 years ago. And so they've come up with a brand new ballot initiative. It's filed. It has over 920,000 signatures, only needed 620,000 signatures. Most of those signatures are valid. And assuming that things go the way they look like they're going, it's going to be on the November ballot in California, and the polls show it has 88% public support, which means come January 1, 2023, you're going to have the amended CCPA, which is going to be amended by the California Privacy Rights Act of 2020. And it's a big deal. I'm going to go through it really quickly because we don't have a lot of time. So I'm going to hit like the top 5 things with a little bit of detail, and like the next 7 or 8 with no detail. 1, it establishes a new category of sensitive personal information and gives the consumer the ability to restrict the use of that data and that data alone, let alone all data. Social security number, passport, financial information, race, ethnicity, religion, union membership. People familiar with the GDPR, this sounds familiar, right? Well, it's a GDPR-like right. Next, This is a freaking huge deal, particularly in the advertising industry. Consumers can prohibit a business from tracking their precise location for advertising purposes. Basically, you can only pinpoint someone to within a third of a mile, 250 acres. You no longer can track how many times somebody goes to Starbucks, how many times they go to the rehab center, how many times or how long they're staying in the gym. Are they sleeping with their wife at home, or are they in separate rooms, or at least are their cell phones in separate rooms? You can't track that anymore. So people with the intention of monetizing intimate personal details, they're going to lose it. Next, email and password are now going to be considered sensitive information. And you give if you have a hacker, getting the email and password, which happens all the time, simple negligence, no proof of actual financial loss, you can have a class action in California on it. This means data breach litigation is going to go through the roof, okay? Number 4, this is gigantic. Establishment of the California Privacy Protection Agency, fully funded, with a level of funding that will enable them to have an enforcement staff the size of the FTC. Except the FTC covers the United States. You're going to have 40 lawyers dedicated to enforcing the California law sitting in California, the same size as the FTC has of privacy professionals. Number 5, the advertising industry has suggested that sharing personal information in behavioral advertising is not the sale of personal information. The CPRA eliminates the distinction. It says that sharing should be treated for the purposes of cross-context behavioral advertising exactly like the sale of personal information. You have the right to opt out from your information being shared as well as sold. The stuff that I'm going to just pop off in 2 seconds: no browser pop-ups, the ability to mark "do not sell my information" on your browser, right to correct data, very GDPR-like, time limits on storing data, data minimization, you only can collect what you need, transparency in profiling and automated decision-making, the restrictions on the transfer of information outside of California. High-risk processors must do annual cyber audits. And finally, what I call the fool me once, shame on you, fool me twice, shame on me provision. No amendments to the California privacy law unless they strengthen them. Period. Full stop, absent another ballot initiative. It is a game changer.
And yeah, this came out, I was at the IPP event in Las Vegas last fall, and Alistair McTaggart was kind of leading this, came up on stage, and it kind of broke on the Wall Street Journal that morning when he was supposed to be on a panel with some FTC attorneys. And needless to say, everybody ran to their phones and then ran out the room pretty much. And it was quite an interesting shift in the panel's discussion, because everybody was kind of like, oh, we're all happy, everybody, we're going to do the CCPA. And then this came out, the language of the new initiative. So there will be ultimately more, panel or webinars about the CPRA. This is going to be kind of, privacy central for the next year and a half, I would think, because if you've done a lot of GDPR work, you got a lot of this work done, and it's not easy, but you should be closer to getting here. But if you said, nope, we're going to isolate Europe, or we're not going to deal with that, we're just going to focus on California, you may be back in this boat. Mike, do you have any comments on CPRA? We can get to questions. I know we have 4 minutes left. If Jason, Mike, Debbie don't have anything to say, we'll kind of hit these last couple questions, but I wanted to give you that opportunity. We'll start with Mike. Anything?
I think, not much more than Wayne. Wayne is very much the expert on this. I will say that there are some very interesting provisions I've read around It may weaken the do not track prohibitions and may make that optional, whereas the AG has indicated it's mandatory. But beyond that, yeah, it is very much going to create something far closer to the GDPR than the CCPA is right now.
Yeah, and I don't see any federal new law the way that Congress is seen before this becomes real.
Yeah, but let me just throw one thing at you that's a really nasty provision in this.
Okay.
If you have California data and you sell it or you share it outside of California, it is deemed to continue to be California data. And so the California law will apply to the person that takes that data in Chicago. And if they then transfer it on to someone in New York, it's still California data. And good background, I really like it. Next time I'll have the pink shirt.
I thought you'd like that, so here we go.
So one question I want to make sure we get to, Jason, you can lead with the response here, is handling ransomware attacks from those employees working from home, and do we see electronic transfer of data becoming more of that risk of exposure for allowing homeward transfers, maybe back to the business unit or to the client? It sounds like it's a policy related. Hopefully there's a policy in effect that says who to contact, but do you have any practical advice to answer the question? I think, yes, it is a concern. That's the easy part, but then it's, what do we do with it?
Yeah, I think there's two aspects to that. One, yeah, it would be good if there is a policy that governs all that, but I would imagine that whatever policy you have probably doesn't cover the extent and type of remote work that we have going on now. And that many times I'm seeing with a lot of clients is that existing policies are just inapplicable to current working conditions, which renders the policy worthless, which is not a good situation. When it comes to preventing whether it's ransomware or electronic fund transfer fraud, the biggest, if you can institute multi-factor authentication and stop RDP access. So multi-factor authentication means if somebody else logs onto your system under your credentials, there'll be some sort of warning that is sent that you'll have some sort of notice that someone else is using your credentials to get onto the system. The limitation of RDP access, the remote, if you're gonna have remote access, use a VPN. The virtual private network is far more secure, and is a much better way to manage. The vast majority of security breaches that I work with are instituted through poor RDP access, and those portals allow for access into the system. And once they're in the system, then they're going to monitor what you're doing. And this is the part where once they're in your system and they're monitoring your behavior, they are so good at mirroring your current processes, mirroring the language of individuals who are requesting payments, mirroring what your vendors would normally do. They are almost indetectable, and they are very, very good at hiding themselves once they're in your system and acting like a valid vendor or acting like a valid customer. They're very hard to distinguish in that aspect. They're very good at mimicking that behavior. So the key is you want to try to keep them out, and you want to have policies. You want to update those to make sure that you're instituting the best practices that you have and that you can have to protect the security.
I think Kevin's wrapping us up. I leave you with one other thing. If you're going to let your employees work from home and you have control, invest $150 and buy them a real router, not the free one they get with their cable company. I think that could be a starting point. But I'll leave it to Kevin then. Thank you everybody for joining. Kevin, you have closing comments or remarks?
No, I just want to thank everybody for joining, and I want to thank all the panelists and Tom for moderating. It's been a great conversation on privacy. So
yeah, I've never done one like this. I have no idea where I'm looking or when I'm supposed to talk, but thank you all for being, this might be the new norm, so we'll get better.
Yes, so excellent. Thank you all very much.
Thank you.
Thank you.
Thanks, Tom. Thanks, everyone.
Thanks.
Have a good day.